Hola amigos y bienvenidos al expediente semanal.
Hey guys, good evening, or whatever it is, wherever you are. And we got some weird stuff happening in cases this week, I think. So seems like everything's working. We were coming toward this here at the last minute. And let's get rolling here. All right. Oops, there we go. All right, let's start out with Maya Kowalski, because that's a civil case before we get into all these criminal cases. It looks like from the voting that people are generally skeptical of the defense motion for a new trial. Absolutely 9. I don't see too many people buying it. Although when I looked at the vote, which was 300 and some people, it was at 96% no way and 4% something else. So, and hello to Los Angeles. And I'm going to roll this back for a minute and say hello to Nicola. Hopefully she's still on because she's been in the chat for quite a while and is from one very cool place, as you guys know. All right, so what's going on in Maya's case? I don't think I'm going to be telling you that. We'll just talk about it a little bit because I think you already know, right, what is happening there. And that is the motion for a new trial based on alleged juror misconduct, which was originally focused on juror number 1 saying that the wife had a great interest in the case and that the evidence showed that she had information she could only get from juror number 1 and vice versa. I didn't really buy that, but that's okay because the defense keeps supplementing this motion, supplementing with fresh new material. I guess they'll keep doing that until the judge makes a decision. And hello to the UK. We got to get into some geography-based stuff here a little bit. We did run with the Scottish criminal last time, so we're bringing it home to North Carolina tonight on dumb criminal section, though. Anyway, as you can see here on the screen, the compelling evidence in this supplement of the horrifying misconduct of juror number 1, which establishes the need for a new trial, is the way that the S's are formed on Sally Smith's name, right? You see that? I think you do. And what they're saying is they go there. I have the big book of motions here. And associating a juror with Nazi, using Nazis, is right there in the motions right before no way. But they're doing it. They're going with it. And, of course, who wouldn't think of Hitler when you're thinking about a medical case in his book that he wrote, which probably precipitated some of his bad behavior, Mein Kampf. And they are saying that Sally Smith is being associated with the horrifying SS troops of the Third Reich. And is that true? Is that really what that means, that those letters look like that? Or is that just speculation? I don't see anything else. And that on their page, well, there is JHACH, which could mean All Children's Hospital, but could also mean John Hopkins Academy for Crazy Hitlers. We don't know. How do we know any of this unless we re-impanel the jury, put them under oath, ask them lots of questions, and from now on in trials have a jury watching the first jury to see if the second jury thinks they did something wrong. You know, the whole thing is, and this can be an issue with letting jurors ask questions, is you get stuff like this, right? But at some point, the judge is going to have to put his foot down, again, because he's already denied one motion to have this juror removed, and that occurred during the case based on the jurors' questions. But that was before the lightning bolt S's were seen, right? So, but is there another explanation? Stormy Northwest Alabama. I almost wore a big parka here to celebrate the entry of winter, but it was almost 70 degrees in Raleigh today, so I just don't think so. Yeah, well, I did read it, and we'll have to say that. You know, I like to see the perspectives of even the crazies. So, but again, are the formation of the letters like this definitive proof, and not mere speculation, but proof. I shouldn't say definitive, but real evidence that this juror was sending a coded message to the judge and the attorneys, right? Why would this juror do that? That this juror thought that that this witness was akin to horrifying shock soldiers of the Nazi Third Reich Empire. There's another explanation that's out there, and that, of course, is the KISS Army. And that could go in one of two ways. If you see the pictures here of Ace Frehley, lead guitarist for KISS, often had a smoking guitar. And the S's in the KISS Army logo are the same as in this letter. Is that a coded message that this juror thinks there's a lot of smoke being blown in this case? Could that be all that this juror meant? Is this actually a coded message to the witness herself? Because you may remember the KISS song, Dr. Love, calling Dr. Love. They call me Dr. Love. I've got the cure you're thinking of. Now, the juror couldn't just propose simple questions like that, but maybe the juror was trying to get this coded message to this witness. Tell us more about these cures that you think could have been used in this case. We can make up anything we want. And there's 250 million-ish reasons why the defense would want to come up with reasons, right? So Nazis, KISS Army, whatever. I don't think this supplement adds to the original motion, which I think the judge is going to deny. And I wish the judge would get on with it so they could stop supplementing it. Now, there are probably strong legal things to talk about in this case, proximate cause, remitting damages and stuff like that. But those are boring, and this is at least entertaining in a terrible way because while, the juror may have brought a little bit of it on himself by, putting himself out there on social media, being called a Nazi and stuff like that, or being accused of calling someone else a Nazi and all this stuff is, come on, people. Come on. I don't buy it. But again, if you've lost a $250 million verdict, you're filing it all, right? And I've got to go back through the docket because this is so stupid that it's caused me to not do it and see if they filed yet legitimate motions. I'm sure they did earlier in the case for proximate cause stuff. And oops, there goes the Apple thumbs up thing. And also, if they filed a motion to the judge yet to remit damages or to reduce damages, which is a serious legal motion and one that should be made in this case, I think, because the damage award is quite high, right? Now, you may think it's justified, you may not, but it's a lot of money. And so the judge does have the power to reduce damages, and you should ask the judge to do that if you want to bring it up to the Court of Appeals later, which you certainly would do for leverage and also possible reversal. So we'll see. That may have been filed. I haven't looked at the docket because I did just look at this, and I kind of stopped there. But I guess you got to do everything you can do, and lawyers are nothing if not sometimes creative, and this is creative. I don't buy it. Even if it were true, I don't really care. If the juror had decided he didn't like this person and, whatever, I don't know. I think if you're going to let jurors write questions and stuff like that, you'll be able to divine in the questions a potential bias or anything else that you want to see. Because remember, they did ask the judge to remove this juror, not because of how these letters were written, but saying that his juror was biased in his questions. And the judge said, "I've watched this juror, I don't buy it," and declined that motion. And this juror was passed into the jury pool, I'm sure, with the consent of the defense, unless they ran out of peremptory challenges. So, and somebody saying it's weird, certainly a choice. I agree with that. There's what's wise to do, and then that's a spectrum that's this large, and then there's what's actually a problem, though, and that's down here. So I don't know. I wouldn't have written y'all at the top of a question that I was submitting to the judge in a serious case, but people deal with stressful situations differently and have different sense of humor and stuff like that. And that might have just been how this jury was trying to exercise demeanor. And so, it is what it is. And I don't think it's going anywhere. So, well, no, I'm going to take a little issue here that Christina says that juror number 1 is a retired cop, so he's not young. He could be young at heart, okay? Because I got to sympathize with that because that's all I got left, okay? So I'm going with the age is just a number. And then, by God, if you want to write y'all at the top of your jury questions, you do it. You go, retired law enforcement officer. And, if you look here now that I'm looking at it, I'm going to make this smaller. You can see up here where it says Zoom. Look at that Z. The top of that Z has like a little thing coming down on it. And I don't know if anybody's tried to correlate that to a Zodiac killer or anything like that. I'm sure this is continuing to be analyzed on certain social media forums that start with the letter R and rhyme with Reddit. And they'll be on to this to make sure that anything else this juror was trying to code into this message will be found out and supplemented again. So, okay. Yes, Mrs. Southern-in-law is informing me that of what this conversation was about. All right, so and hello to Liverpool. That was the whole point of getting this comment up here. All right, so I started out with the Maya case because it's a civil case and not a criminal case, and we get it. It's bad as it is, and it is terrible for all sides on this, and it's, the circumstances are horrible. It's not a criminal case, so we'll move into those. Here's your boy, Daryl Brooks. Some people have said, have I missed Daryl Brooks? Well, there's not much to miss, of course. Here's, soon we'll be able to wish him a crappy new year. But he does have a new lawyer, so things are looking up for him there as he closes out this year. Darrell or whatever it's going to go by. Russell Jones is the attorney, and you see this bumper sticker-esque thing that was on his website that says allegedly, so I like that. They got a little humor in their office, too. And he's appointed to assist Brooks with his remaining charges, which really deal with Erica's cases. And the more interesting one, of course, is the intimidation aspect to that. But what's Brooks going to do? We don't know. Is he going to try and fire this lawyer later? We don't know that either. They should have a status hearing next week. I think it's the 14th. The judge will then set it over for whatever happens next. So I don't think there'll be any news or anything until sometime next year with this buffoon. Same thing with his appeal, although I think the attorney has a deadline running now that might actually come before the end of the year to either file something on the appeal, not the appeal itself, but like the notice and stuff or whatever, but might just file the one-page notice or get an extension, which happens a lot. So we'll see. Yeah, now I want a peppermint patty. I knew it reminded me of something, and thank you for reminding me of what it was reminding me of. Here's Little Rock. Of course, you see Little Rock on Eric streams a lot, and Laid Back News, which I wasn't able to be on yesterday, but it's a fun show because some lawyers on there with a lot of good thinking power that I enjoy listening to and sometimes chiming in on it. But thanks very much, and good luck with all trials and grandfather duty. I think the grandfather duty is probably the more difficult there, but your cross-examination skills could prove extremely useful in family environments like that. When you get out of law school, one of the things you did early in the old days, you'd start talking to your family instead of normally you'd say, well, A, this, that, and the other, and then B, and this, that, and the other. But that wears off. But your ability to be annoying and how you ask questions, cross-examining family members and friends, that never goes away. That's a gift that you get to keep from law school for your whole life. Hello to Australia. And I didn't play the Australia intro this time, but I'll do it next time because it is so cool sounding. And hopefully people will send more of those. I like hearing people's voices from around the world and putting those into the show. So the Mrs. Southern-in-law has decorated the office with this tiny Christmas tree, giving it the festive atmosphere, and a real candle that she advised me not to knock off the shelf and set all of these things on fire, especially this Bible concordance that it's on, which was published just after the Civil War was over. So that would be a shame, and I won't do it. All right, let's take off away from Daryl Brooks, unless anybody's got any questions on him, but I think that's pretty much his whole scenario there. It is what it is. It's always fun to watch him lose more, and hopefully continues to do that. Let's see. And Gringo says, I love Australian accents. Yes, and who wouldn't, right? I mean, you got to love that. Okay. That's awesome. And thanks to Little Rock for giving out more memberships. And Nicola's done that a bunch too, even on this stream, and she's done it in the past. And I'll mention, if you get these, you can then go on the member side, and I have a bunch of live streams that, except for the very last one, they're all voted on by the members, and they can be whatever legal topic that happens to be coming up then. And it might be a deep dive on something that's about a case or something about the legal system that you want to know more about how it works or whatever. When we put the vote up and you vote for it, then that's what we talk about. So there's a little library of those, focusing largely on criminal cases that you can find. And if you want them, free stickers, you just have to send me an email, and I'll send those out. And once I get rid of the first run of stickers, I'll do better and try and beat this allegedly one up here. So let's let's keep it going here. Chad Doerman. You know, I need to put these guys' names up because there's so many cases now. I'm looking around. Look at this thing they got here. So you remember they wanted him to be able to waltz in a tuxedo and sashay around the courtroom and stuff and show the jury that he's just an everyday guy, just an everyday guy in court, happy to kill his family annihilator, you know, but, you know, just a normal guy, really. Well, he was feeling sorry for himself in this picture that you see here, but he would also have this expression if he were looking at this device that the judge said, I'll let you wear street clothes, but you're going to have this knee restraint on. And I think if you watch some of the cases we've seen, you probably realize this is something they've been using on defendants. And so it restricts movement. If the person tries to get up and start kicking people or running away or whatever, this thing is supposed to make that very difficult to happen. And that's what he'll have to wear. So he didn't get everything he wanted, but he'll be able to at least look like, if he can look normal, then it won't be, if he doesn't look normal, it won't be the judge's fault. The judge is going to let him wear this weirdo thing. Too bad he doesn't have to wear it around his head, but it is what it is. Man, I am slow on the draw here. Hello to Kentucky. Good old Kentucky. I have a lot of horses in Kentucky. When I had to go there for something, they said, you know, if you have your trailer there with a horse in it and you leave it there and you come back and you find out somebody may have broken into it, and then there'll be 2 horses because that's how many horses are around there. But if you had a good donkey, that was something people would want. Washington State. That is awesome. And so somebody says, I've never seen one of these. Well, you know, I really haven't either, but I think sometimes realize people are, hey, are they wearing something weird under their suit or whatever they're wearing? It might be something like this. Because the goal there is to have safety in the courtroom, but also to the degree you can not make it look to the jury like this person is about to burst out of the chair and attack everybody. You don't want that look either, in theory, at least, for a good high-functioning legal system. Tracy Ferriter, she said, I'm poor, I'm indigent, you got to give me a lawyer. And she's got a lawyer, and then she says, I'm not poor, I'll get my own lawyer. And then this lawyer, they have a little picture there. She said, I need to get out because I now have irreconcilable differences with Miss Ferriter. I don't know what those were. I don't think the judge made her explain what you shouldn't do anyway. And the judge said, well, I'm going to let you out. And this new lawyer you're telling me you want to come up with, I think the judge gave her 2 weeks or something like that, 10 days or whatever. That lawyer needs to appear by then and tell me when the attorney is ready to go to trial. So this judge is not fooling around, and wants this case to move forward, is not going to have discussions about attorneys slowing the case down a lot. And again, that's this whole balance about Sixth Amendment versus a reasonable trial docket. And the judge is saying, here, get this lawyer and get him into court if you're not wanting an appointed attorney. And that's fair. She has a Sixth Amendment right to choose her counsel and select counsel. But on the other hand, you can't just slow down the system forever. I'm sure a judge will give more time if the attorney needs it, but it'll keep the heat on, keep it simmering, keep it moving. And Mrs. Southern-in-law is betting that Mrs. Ferriter here will get less time than her husband because of slightly less culpability in terms of overall actions while they were both disgusting in how they behaved. And while old Tim got a downward departure on his sentence, I would say that's probably right? I mean, probably Tracy's going to get something less. Is she going to be able to get a plea bargain and be willing to go to prison for a little bit or jail or whatever? We'll see. You know, they rolled the dice on the first one and lost. Okay, he could have been a long way through his sentence already, so we'll have to see. And Little Rock says the Public Defender Department in Little Rock has complained about 99% of defendants qualifying for indigence. Seen the prosecutor helping the defendant fill out a form ensuring qualification. Yeah, of course, you know, with rising legal costs, probably a lot of people do qualify for that, I suppose. And, you know, the standards can be pretty light on that. It is interesting to see around the country who assigns the defenders, you know, whether it happens in court or the clerk does it, or even, I think Wisconsin, I think the public defender's office assigns that. So it's interesting. Piedmont, North Carolina. Nice. As we're over here at the Triangle or Research Triangle Park. We're on the very edge of that. We're at the cow researching part of it at NC State University. That's what's being researched, exactly where we are, the cows, and how to make ice cream out of them, what they produce. So that's what we're doing. But a few miles west of us, they're making cool drugs and stuff. All right. Sarah Boone, I just put her on here. I had a placeholder in case something happened, and I was wondering about it in this respect. This is nothing on the attorney that she's got, but this is more about her, which is the attorney was appointed in September, I think, and made an appearance in late October, actually in court for a hearing, and they got a status date set in January, mid-January, I think. So if you remember, the last attorney abandoned ship after filing a motion for this $400 an hour expert that, in theory, I suppose, might help Sarah Boone's idea that she wants to say she was a battered spouse as a defense to the charges. But they never got that expert appointed, I think. So that motion was pending. I don't know that the judge ever ruled on it. I was curious if this new attorney was going to calendar that motion for hearing and say, Judge, I adopt that. Can we go ahead and get a decision on that? But I think it's still floating in the ether. I do know the judge said to the attorney, while I'm setting a status conference in mid-January, do not wait until mid-January to do anything. If you got discovery things and stuff like that, get on it. But here we are in mid-December, and I don't think anything's happened on the docket. But then again, Sarah has not written another letter. So there could be something going on in the background where they're putting her defense together the way that she's satisfied with. It doesn't involve the new expert. It's just interesting to see her docket quiet this period of time without her getting that one mighty pin out that she has and writing a letter to the entire world about her truth. Well, it says it's really been that long since the last attorney was appointed. I think on the docket it was made in September, right around the end of it, but he didn't show up for a hearing or wasn't scheduled for a hearing until the end of October, or right at the end of October. That's why it seems so recent. And it is pretty recent, but now we're in December, and with a status conference coming to January, I wondered if we'd see some action. Somebody says, I've always wondered how indigent you have to be to qualify for a public defender. I think I went over the standards for Florida and this state in a stream that I did on Sarah and her journey through attorneys. As she's been through so many of them, a half dozen, 7, 8, I don't know, the whole Florida State Bar or whatever. She should probably be the bar president at this point. She's met all the attorneys. Probably no one else has done that. But anyway, I did put that. I think I did Wisconsin, North Carolina, and Florida, how the language works for that. So if you want to check that out. Somebody sent you. Okay, yes, thank you. She finally ran out of ink. She will reboot, I feel like, but that would be kind of funny if that were the reason we don't have a letter is she doesn't have the mighty pen that she has. And this is a good picture of her, an endorsement of that pen, because she says she has one, and Lord knows it can spill a lot of ink. So we'll see what happens with her, but all quiet on the whining front continues. This is not a funny one. Of course, this is Ethan Crumbley, who had his sentencing hearing, and that just happened yesterday. They had a prior hearing to that as to whether he would be eligible for life without parole because of his age, time of the crime, and the judge decided that he could be. And, you can listen to some of or all of the witness victim impact statements. And what he said, what Ethan Crumbley said, which is, I'm a bad person. I did this. I couldn't stop myself, but it was the choices that I was making. And I deserve whatever sentence the family wants in this case because they ought not to have to fear me anymore. So that's what he said. He also said he was going to try to do better. I mean, none of that mitigates or is an excuse for anything he did. But if you're going to say something after you've done something like this, that's probably the right thing to say. Kind of reminded me when Jeffrey Dahmer was in an interview and basically said, look, I can't help how I am. I'm where I need to be. If you were to let me out of here, you're looking mighty tasty right now. So, I put a little seasoning on you myself. And so he recognized that he was nobody who needed to be out free. And Crumbley here, at least during this hearing, was owning up to what he did, I guess, to the degree that you possibly could try to do that after the horrors that he committed. How his head got so twisted, I don't know. He did say, don't blame the school, don't blame my parents. I didn't tell them what I was going to do. As parents, of course, are charged with manslaughter, and that's interesting from an approximate cause viewpoint compared to some other charges, because they're actually charged with being responsible for deaths in that case. And normally the intentional criminal act of a third party would break that proximate causation chain. So sometimes you see other charges like, safe storage laws and things like that they don't have or didn't have in the state. Still don't think that they do. So that's what they're going with. And the Court of Appeals has allowed it to move forward. The Michigan Supreme Court declined to intervene. So his parents are going to go to trial. Now, I fully respect the legal arguments about that. And if you want to see that, then you should watch Michigan Making Law Simple, Michigan, Dave, his channel, because he does a great job of talking about the law there on that. Now, he doesn't try to say, and it certainly is against what I'm about to say, and it certainly is my contention, the parents' behavior with regard to the firearm and this kid is incredibly irresponsible. Incredibly irresponsible. I mean, it frustrates, I guess, some people that watch this channel sometimes, but I mean, we have a lot of guns, okay? We're people in the South, used to shoot competitively as an Army and stuff, so we got a lot of guns. The fact that I have the legal right to have those and doesn't take away from the fact that I have a responsibility for something like that. And if I had somebody in the house who I knew was hearing voices and seeing things, I would be pretty careful with that. So I just feel like that they did the wrong thing in this case. Now, whether that warrants manslaughter charges, that's a different situation. And this is, I think, a good comment for the no winners in this Crumbley situation. Yeah, that's for sure. And he also said his parents didn't know at all, so their case would be interesting if he testifies. Right. And that will be an active issue, is the level of knowledge they have, because even if they were to lose a trial, they still have an argument when this case is over on the proximate cause issue. That's not completely done. It's somewhat fact dependent on what gets proven at trial. So we will see. Parents were extremely negligent. Yeah, I feel like they were based on the things that I've seen. Okay, and that's not to say that the school wasn't negligent too. Yeah, somebody just said no winners here and there. Unfortunately, like a lot of disasters, like I used to fly, and a lot of things. If you had a crash in a plane or a crash occurred, you had that final point of failure, but usually you'd back up that chain of causation, right, and find that there was a series of things that could have prevented the crash from occurring. And that's the case here with this disaster. Is he showed up, and it was his intent that day to do what he did, which is kill his classmates. But there were a series of events that occurred before that where people could have intervened, and that included the school and his own family. And that's terrible. Little Rock says I had a lot of guns in the house too, but responsible to not have them within reach of grandchildren. I try to hide them from wife too, but just good as hide and seek. Yeah. And that's the same thing here. If kids are coming over, or when kids have ever been here, that's part of my job, is to make sure those things are not where they can hurt people who don't have any business with them. Now, in terms of having to worry about Mrs. Southern-in-law and I, we solved that a long time ago. When we buy one gun, we buy two. There's the old saying in law enforcement and other things: or in the Army, two is one, one is none. And that's how it is. So if I get one SIG P365, then we get two SIG P365s, and we don't have to worry about who's got what. And that's good for pretty much anything that you buy, not just firearms, is to reduce the potential for conflict. All right, let's talk about old Jessy here. Kurczewski, I think, is how they're pronouncing her name. I'm no expert on name pronouncing, being from the South, but I'm close enough to Duke that Kurczewski is just probably how I'll have to say it. Anyway, there's this fake alibi letter, right? It's obviously fake that the woman who was murdered didn't write any of this stuff, but is the letter itself fake? Because that's what Jessy says. Now, the attorneys are out and the sentencing's postponed. I have several things about this on here. Oh boy, let's go here. Let me make this bigger so I can see what we're talking about. Okay, so this was a motion to withdraw here. And the attorney says, my interest of protecting my law license of 27 years are at issue here. I will remain silent if the court proceeds with the sentencing. Now, this gets the attention of a judge, of course, when you're making a motion to withdraw, that you feel like it is this serious. And it's not on this page, but I think it wasn't a motion they filed, or maybe another letter or something that they actually called the State Bar Ethics Committee or hotline or whatever, and they agreed this is the right thing to do to withdraw here. And it is the right thing because they've been implicated in this letter. And I agreed with that. And, judges don't want to see you leave out of the case when you only got one thing left to do. On the other hand, normally there's a limit to how far they'll press into conflicts. But in this case, what the issue is pretty apparent, which is the letter alleges that an attorney was involved in it, that an attorney had the idea or helped with the idea and then helped smuggle this letter out. Now, I'm not saying I believe that stuff, but that was a contention in the letter. Of course, the defendant, or she's convicted now, says, I didn't write that letter, and that could be a big issue, but you don't need to be putting her attorneys on the spot about that. If they feel like a conflict is there, you have to respect it. And in fact, Jessy said that she had no issue with them withdrawing. Somebody says, my opinion is she wrote that letter herself. I agree, and we'll take a look at it here for a second. Nicola's back in the game with setting this membership record. So many members coming in on the stream. I hope the content that you find there in the member section, it makes it worthwhile, because I do try to do that. It's a weird thing. I have to explain that sometime. Anyway, here's some features out of this letter. Nobody will know if it's her or not. This is talking about making a recording. It's been 5 years. Do a fake notary in a raspy voice and put an old music or movie thing on. And she even gave a script to her friend. And we'll look at a little bit of this in greater detail. I added some slides onto this from where it originally started. So the goal of this letter was to say that the victim in this case killed herself with eye drops because she had killed her own mother the same way and lived with the guilt. So this is some Agatha Christie style plot twist here that old Jessy wants you to buy into. All right. So the state was interesting because they said, we don't want you to grant this motion to withdraw, Judge. We want to have the sentencing hearing for the good reason that if you got the victims ready to discuss it, we don't want to put it off. And for the almost laughable reason of their concern that the defendant was languishing in jail until the sentence was given down. And given that Jessy wants a continuance herself, yeah, I don't think so. Let's look at a couple more of these. So they do say, the prosecution says in the letter that they sent to the court that there are notes from the trial, right? The trial notes are on the back of some of the pages, which gives an air of authenticity to this letter if you're trying to say that Jessy wrote it, if it contains on one side of it a document that was there during her trial. And I don't believe that she didn't write it. She did write it, right? So that's my opinion here. But look at some of the stuff she says here. She's channeling some of the true crime subreddits. She's fighting a lost cause. This county is so crooked. Every county in the United States is completely crooked. There's never been anybody placed into custody who did anything wrong. It's always a setup. It's always the Illuminati. Someone will believe that, but I think most people in this case will not believe her. I don't even know if she can sell that on social media. It's not even funny, she says, which I agree. It's not funny. You murdered somebody as you attempted to try and get her money, and now you're trying to concoct fraudulent documents to overturn a correct jury verdict. That's not exactly hilarious. I talked with one of my attorneys about stuff in person, and I got a biggie for you to ask of you. I trust you, and whether you help me or not, this is something I need you to take to your grave. Well, if somebody was convicted of murder and told me that statement, it might slow me down a little bit. Even this envelope didn't go through jail mail because my attorney took it. This was one of my attorney's ideas, and clearly they aren't going to tell anyone. I will never tell a soul. You can tell someone if it's to ask for help, only if you trust them. Oh, yeah. This is starting off great. And do not talk about this on the phone or visit. All right. So this is all an up and up, right? She starts the letter talking about how crooked the county is. And then she starts talking about how what she's about to propose has to go to the grave and can't be discussed with anybody. Now, I'm going to pause this for a second to say, here's the comment. I'm jealous of the uniform handwriting. Agree. I will write something, and immediately upon finishing what I just wrote, I cannot read it or recall what it was. Here's things you'd need, Jessy says. A computer, paper, envelopes. This is very thorough, right? If you're going to do a letter, you need paper. She doesn't omit that from the list, okay? Paper, envelopes, stamps, address labels, cassette, old school, cheap ones. Able to record voice. That's important if you're going to do a voice record. Gloves are a must, okay? Make sure you wear gloves because you're not getting in trouble. You're helping me. And when I tell somebody I need a favor, and I'm going to need you to wear surgical gloves at all times, that's because I know they're not getting in trouble, right? Why would you think what I'm suggesting would get you in any trouble? Anything you do buy, do it at a store, not in Waukesha, and do it with cash at like Walmart self-checkout. Yeah, because you're not getting in trouble. You're not doing anything wrong. You're just needing to wear gloves at all times and shop out of town at Walmart with cash. Okay. Daryl Brooks writes like this, somebody says. And then here's the letter that's supposed to go to the judge, because part of what old Jessy put together was a fake backstory of how this evidence was recovered by this concerned citizen who's going to write into the judge, helpfully putting in the reline that it's not just Jessy Kurczewski, it's also the Visine trial. Sample, it says at the top. All right. Don't use this. This is a sample, right? This something like this. Don't say who you are. You're just a concerned citizen. I've watched this trial from the beginning. I never met this girl, Jessy Kurczewski, but I can tell you this story's crazy. Anybody who has a brain can tell you this girl didn't do that. Those jurors didn't hear, or what the judge didn't allow makes no sense. You're talking about this girl's whole life because Lynn took her own life. How's that murder? It was a total setup. If I ever saw one by Waukesha County. Well, I spent 3 days in the park, Whitehall Park. Why the detectives never took her to the park and yelled at her repeatedly, I don't know. So the idea is this citizen who's supposed to write in, for Agatha Christie, is supposed to write in and say that they found this will that gives everything to Jessy and this confession letter from the murder victim saying, I previously murdered my mother, so I killed myself. And the one thing I want to make clear before I do finish killing myself is Jessy has nothing to do with me dying. She's actually the greatest person of all. And I really like her, and she's kind and generous, and she's very cute, and she's nice, and she has a good singing voice, and all these positive things about Jessy, curiously, in this confession letter, and it's stupid. So here's some fake notary stuff here, where she's showing a sample here and talking about make sure all the lines are the same, and how to find fake notaries and where to put it on the paper. And send these letters to these attorneys and court TV and news stations and the DA's office and the judge, and get this stuff out there. Now, remember, as she said many times, wear gloves for all. Okay. Wear gloves for all. And she said, make sure you don't use any kind of new movie or something, because they'll figure that out, right? The corrupt law enforcement of Waukesha County will figure it out if you use Squid Game in the background when you're writing a letter that supposedly was written like 8 years ago. Jessy's got the noodle on her. I think she thought the Visine was going to do it, that nobody would catch her on that. She can't believe it, and I'm kind of surprised too. So I hear her on that, but it is what it is. So the jury saw through that. I can't even believe she managed to act so surprised that she was convicted, but she hasn't given up. She's going to keep on trying. And the judge, of course, said, listen, we need this whole letter thing raises a lot of questions. Why don't we grant the continuance that the defendant wants? And by that time, the state can figure out more about this letter, because she's saying, I didn't write this. And I don't believe that, but whatever. I'm not even sure it's truly going to be material to the sentence she gets, but I understand it could be, because it shows the mindset that she's got. It's hilarious because she obviously thinks this is clever. It is a lot of detail, but it's a little too much detail, I think. I think that it could be a fun chain letter. It is interesting. If it weren't so serious, it would be a great, she could have had a career like escape rooms, setting up scenarios for that, or one of those dinner mysteries where you show up at the strip mall and they've configured it to have a murder mystery for the night, or you're on a train or something like that. She could have been a great hostess for that if she hadn't decided to do it in real life, the killing people part of it. So that's unfortunate, I think. All right, so Hannah Payne. Flip this script back up there. And I think some of you were commenting on it with this case earlier, and I have had it running in the background some this week and listening to it. So there was a 60-some-year-old guy, and he crashed into an 18-wheeler. There was some question about whether he was having any kind of diabetic reaction or something like that. For whatever reason, he appeared very disoriented at the scene. That could have been a result from the crash, but also the crash could have been a result of his medical condition. I don't know the answer to that. But after a period of time, he decided he was going to leave the scene. And they didn't want him to, the people there, but that's what he was going to do, and that's what he did. So this young lady, Hannah Payne, decided to follow him. And she told 911 that she was doing it, and they told her, don't do that. But she did it anyway. And she ended up getting her Jeep in front of this guy's truck. There was a lot of traffic around, and people videoed some of this or all of it, and there's witnesses and stuff. So she gets her Jeep oriented in front of this guy's vehicle. He doesn't get out of his vehicle. She gets out of her vehicle. She goes to his vehicle and goes to the window of the driver's side, and something's going on there. I think it's pretty much a fact that she was telling him to get out of the car. She's not law enforcement. She's not anybody. She wasn't even, I think, in the wreck. She's just butthurt that this guy left the scene, even though they had his tag and stuff. And they didn't want her to follow him. And she did. She could have done that and left it there, given an update on where he was and stuff. But she decided to try and pin him and get out, and pulled a gun out. She pulled the gun out. This guy didn't have a gun. And then her allegation is that somehow he pulled the trigger or caused the trigger to be pulled. I mean, he never left his car. So for that to happen, she had to chase him miles down the road, get out of her vehicle, stop her vehicle, get out of her vehicle, go to this guy's vehicle, draw her gun, and then put her gun where his arm could reach it, which I think was inside of his car. And that's, no. I don't know what class she took, if she took a class on how to use a firearm appropriately. And especially if you're going to, if your theory is it's going to be self-defense, but you do not use your gun as a way to instigate situations. You do not do that. If she wasn't willing to do what she was going to do without the gun, she shouldn't have done it with the gun. The guy wasn't threatening her life. He didn't get out of the car. She should never have drawn that firearm. And I think she deserves to go to jail for that. That's my opinion on this one. That she has got some pain coming her way, I think. I don't know what her thought process was. I don't know why she did what she did, but she shot this guy in the abdomen and he died. So, I mean, that's what it is. I mean, again, I'm a pro-gun person, but you got to be responsible with it. I mean, you could think you could put a cape on any time of the day because you have a gun with you and then go around and fight crime yourself. And when it involves chasing an old guy down who just had an accident with an 18-wheeler, so how bad off was the 18-wheeler guy if this guy was okay? And get out of your car and go to his window screaming at him to get out of his car and put your gun inside of his window. I don't think you're Batman there, okay? I think you have screwed up. So her attorney is cringe is the comment, and the state is flying through witnesses. Yeah, it's kind of fun to listen to him in his opening statement because it just is like, I mean, what has this poor guy got to work with? What has he got to work with? So he's been quibbling with witnesses over, are you sure you actually saw this exact thing or not? The old saying is, if the facts are on your side, pound on the facts. And if the law's on your side, pound on the law. And if you don't have either one, just pound on the table. And I feel like that's what this poor guy has got in this case. He's giving it the old college try of appearing emotionally charged for the injustice being done to have this woman on trial. But when he goes home at night, is that what he really thinks? Yeah, pro-trigger discipline. Every single aspect of this, I agree, was mishandled by her. And no, I don't think that's how it goes. Absolutely not. No. He should never have known she had a gun. She didn't need to pull that gun out. She shouldn't have gone to his window, but if she did, she shouldn't have turned that into a lethal force situation, because if she pulls her gun out and he sees her coming with a gun toward his car, how does she know he doesn't have a gun? And then he's going to pull it out. And she's got no business doing that. It's all bad in her case, in my opinion. So young and dumb, and she's got the lessons to learn, but I think she has wrecked. She ended someone's life and has wrecked her life, and why that happened that day, I don't know. But that's my opinion on that case for what I'm seeing. Somebody says, I see how they pulled a witness off the stand so her memory could be refreshed in private. I didn't, and so if that's this case, that's interesting. Not sure what that was or how you can do that. Normally that happens on the stand, right? So that's bizarre. I guess it depends on who it was or whatever, and what was happening. I'll try and find out about that, though, because that's interesting, and see if I can comment on that next week. That's obviously unusual. I had to slide in here also as a placekeeper in case something strange, really strange, blew up in the Alec Murdaugh case, because all the shenanigans down there with the clerk and her family. Her son's been charged criminally. There's some kind of investigations going on with the clerk, and that's not good if you think that Murdaugh committed these murders and you want the verdict to be upheld, because there's going to be, I think, an evidentiary hearing, and there'll have to be a decision by a judge on whether the judge concludes that the clerk talked to the jurors about this case or not, and her credibility is not enhanced if she's under various ethics issues that surrounded the time of this trial. And of course, it'll ultimately depend to some degree on what jurors actually say if they do the evidentiary hearing. But I guess I think there's a good likelihood that his verdict will be thrown out. And I happen to be one of the lawyers who thinks he did do it. Some think he didn't do it. They really feel like he didn't do it. And also some of them think, well, the state didn't prove the case enough to say that he did it. And those aren't the same positions, but they're different than mine, which is I think that he did do it. And I think there was enough evidence for the jury to conclude it, but certainly, it was a tight one. I can't say that somebody who thinks they didn't prove the case is just out smoking crack or something, because that's a reasonable position too. So. All right, so it's a male witness who recorded a video. I do remember that guy, and I think they were showing, if it's the same guy, I think they were showing some still pictures of his. And I'll have to look at that, because I wonder if they let him go actually, if they weren't showing the video to the jury, I wonder, because I remember seeing still pictures, maybe they let him watch that or something. I'll have to check that out. That's interesting. So yeah, Mrs. Southern-in-law thinks that Payne was on something to do what she did. I don't know. I don't know if she's going to testify or not. I mean, probably not. Usually people don't, but if your idea is looking at the evidence that's up there that you're going to try and blame this guy for what happened, well, he can't give an explanation. You killed him. And if you don't give one either, I think the fair reading of the evidence is you shot him. Okay. That's what it looked like to me. So we don't have to, reasonable doubt doesn't require that you imagine possibilities. It has to be reasonable doubt. You got out of your car with a gun. You walked over to his car with a gun. You pulled your gun out. You pointed the gun at him. The gun at one point was inside of the threshold of his car, and he gets shot. Yeah, your hand is in the cookie jar, and the cookie's gone. I'm blaming you for it. So yeah, it's just somebody saying that take a break, and the guy refreshed his memory. So maybe he looked at something that they didn't want the jury to see or whatever. So, but still, it's interesting. I'll check it out. Thanks for bringing that up. Let's go to prima Donna Adelson, who's having some struggles with how she's being treated by the Florida confinement authorities there. Leon County Jail, I think is whatever. It's where she's at now. She's got some issues with that. She's not really stoked about what's going on. Let's make this big enough to read here. Her attorneys note that she's a 73-year-old grandmother arrested in Miami, Florida. Their son was charged. The evidence against Donna is circumstantial at best. And that's a good sentence to put in there, but circumstantial is enough. Anyway, when it's good evidence, the official said at one point, they talked about the things that people in the new jail are saying to her. You'll learn that fancy white lady murderers have no rights here. You see where you are and you see where I'm at? I'm out here because I'm not a murderer. Whereas they say other jail staff said, why are you being treated like this? So the whole thing is she's saying that the new jail that she's at, she's being held in confinement unnecessarily, in an unnecessarily strict way. She should be like a gen pop so that she can call her family and also call her legal team and do other things like that. And remember, the point of pretrial confinement is not punishment, because I have seen a lot of comments like, haha, don't murder people, and you don't have to worry about how you get treated. I appreciate that. I don't like murderers either at all. But on the other hand, she's not a convicted murderer yet. And so the concept is, how does the system treat somebody who's merely charged with a crime, whether it's somebody you hate, if you hate her, or if it's somebody else, or somebody who you think is wrongly being confined. Like a lot of people think that Richard Allen is innocent, or that the case can't be proven, and they're upset with how he's being held in confinement. And I'm sympathetic to that because he hasn't been convicted yet. So the state in this position, at least according to what I saw from the defense motion where they consulted with the DA side, defers to the judge on ordering change in conditions. And that's almost an agreement in that case. I mean, they're not going to say she has to be in, some kind of solitary confinement. And they also don't oppose an independent psychiatric exam if that's what the issue is that the jail is having. Her attorneys also put something in there about she should be on house arrest, and the state opposes that. And of course that's laughable, but it does give the judge something. You're throwing a bone to the judge to say, you don't have to be soft on crime. Let me ask you whether she can go under house arrest, and you can tell me how absolutely insane that is. But then you can at least say, but don't keep this woman in whatever kind of confinement she's in, because she should be able to work with her attorneys and build her case up. Because remember, the point of pretrial confinement, as I said, was not punishment. What it is supposed to be is to prevent flight risk, and she is one, and prevent or protect society. Prevent danger to society is also a thing you can use to justify pretrial confinement. Those are the reasons, because the person hasn't been convicted of the crime yet. Punishment is not the reason. So you don't really want to have people be unnecessarily restricted in prison in some kind of solitary confinement thing like supermax, like they're Ted Bundy that's already been convicted or something. The idea is you should have, unless you're causing problems and things, the ability to work with your attorneys and prepare your defense. And then when you lose, you go to prison and you get a worse treatment then. So, yeah. So that's my angle on that is, while I agree that you shouldn't have the unnecessarily strict confinement conditions, it doesn't mean that you buy it, everything that a defendant says with whole cloth. Like, you wouldn't believe how mean to me out of there. I should be able to frolic through the fields and meadows, gardens, and sit at home like Tim Ferriter keeps asking to be let at home. On the other hand, I think it's an interesting thing to say. I think jail should be able to throw people in solitary confinement without any conviction at all. I think that in the middle there somewhere where the system ought to operate, and it usually does. So that's just my opinion. All right. Why would you testify? There's nothing you could say that would make sense. Is talking about the Hannah Payne thing. Yeah, well, I can't argue with you if you're talking about Hannah there. There may not be anything that she can say to make sense. But they do have a concocted theory that the guy pulled the trigger or did something that caused the gun to go off. Well, nobody saw that happen except her. She would be the only witness to that occurring. So if you want something other than speculation, you need her to testify about it, but maybe she won't. I mean, probably not, right? So we'll see. Was the state obligated to submit this letter to the court? I don't think so. I don't think that they had to. I think they just did it as part of the sentencing. They wanted the judge to consider it as part of sentencing. So no, I don't think so. And not to any thing that I have knowledge of. In fact, the judge said, you're still checking to see whether she actually wrote this or not. So if you want me to consider this, we ought to probably know that. So I think they think it is relevant for the judge, though, because it shows a mindset of deviousness, continued deviousness. She's not like, I should never have done that. It's time for me to own up and accept what I did, which could weigh into what the judge does on sentencing. Instead, it's showing this woman is going to continue to lie, cheat, and steal. She hasn't accepted responsibility for anything she's done. She's willing to bring other people into a new criminal enterprise to fabricate evidence to try and thwart justice. Because part of that's all part of the weighing of a sentencing. Because remember, even Darrell Brooks in Wisconsin had a sentencing hearing because they have to weigh these factors. And it's particularly important if you were trying to give somebody a life without parole, although I don't think they call it parole up there anymore. But still, if you want a whole life sentence or whatever terminology they call it, I think they call it extended supervision. You gotta walk through the process. And so if you're the state and you don't want her to have the possibility to get out, then you want to show she's of such bad character that she's never going to not be a danger to other people. And here's about Donna. She's the very definition of flight risk. Agree. Fully agree. So under no circumstances should she be let out of pretrial confinement. I agree. I would not trust her with an ankle monitor. She would just cut her ankle off or something like that and get it taken off in whatever boat she sails to some remote island. Yeah. All right. Let's move this slide along here. And I got Richard Allen in here because I was waiting to see what was going on with that. The Supreme Court, to my knowledge, last time I looked at the docket, had not ruled on the two writs that Allen's team of attorneys have filed for, the public access to various documents, asking for the judge to be removed, the attorneys reinstated, and a speedy trial. The Supreme Court has not ruled on that. But what was weird that did happen is he got moved. Okay, they moved him again to another prison, and the prison is at a greater distance from where his trial will be than the first one. And is that bizarre? It is a little bizarre to me because they spend a lot of time saying he doesn't need to be put into a jail facility closer to where his trial will be and his family stuff because the prison he's in, it's just great. It's fine. He's being treated like anybody else there. It's all good. He's getting medical care. Everything's great. Anything you don't like, we're not doing it anymore. It's a great place to be while you're waiting for your trial. And then while these writs are pending, they move him to a different prison. I don't know about all the timing of things up there, I guess I would have to say. This is just a weird case, unfortunately. Again, I think, I would rather analyze the circumstantial case and talk about where the state has some points and where you could challenge the state's case. But this thing is caught up in this whole procedural nightmare, right? That's just a disaster. And this is weird, moving him. I think he's almost 3 hours away now from Carroll County Courthouse. Or at least that's what I saw. All right, so I think that's it for these crime cases. Let's venture into the realm of criminals who are not exactly rocket scientists. And we went overseas last time. We won't exercise a passport this time. We went to Scotland last time. We will take it to North Carolina, which of course has a lot of Scottish influence, but I won't blame Scotland for this story. I'll blame our local state authorities for what's happening in this state. Anyway, let's say you're a young man. There's a Anthony Goddard there, Charlotte Vehicle Liberator, I think would be on his business card. You've been arrested for stealing a car. It's not even the first time. You get a bond of $3,000, which basically probably requires you to put up $300, and then the bond company puts up the rest. They let you out. That's great, right? So somebody just stealing cars over and over gets out at $300. Thanks, bonding agent, for making the magic happen and getting me my freedom back. You're out. Jail door opens. You roll right on down there. What do you do? What's your next step? Well, what this gentleman decided to do was look around and think, well, I'm out. I got to get home. And what am I good at? What am I good at? Well, one thing I'm good at is stealing cars. So he steals a car right there, okay, at the courthouse in the jail. And he steals a bonding agent's car, okay? And the bonding agent doesn't appreciate it. So she alerts all the bonding companies around to make sure that this gentleman has a tough time getting anybody to put any bond up for him the next time he's caught, and his bond probably be higher. But he's an enterprising person that's doing something that's very popular in Charlotte. Vehicle thefts, as you see here, are 1,468 compared to 738 in 2022. So they got a 100% increase in vehicle thefts in the Queen City. Charlotte has always thought of itself as something better than the rest of North Carolina, and it has continued to excel in the category of vehicle thefts. It was even home for a pro football team at one point called the Carolina Panthers. I don't think legally they can be called a professional football team at this point if you look at their record. They've had the ball stolen from them more times than people are stealing cars in Charlotte. Is this considered grand theft auto? Well, good question. I didn't look up what his actual charges are. What I read in the story, it didn't say that especially, so I'm not sure what they charged him with actually under the statutes. I have to look and say. Horrible roads down there. Any road that leads to Charlotte is a horrible road, in my opinion. But not everybody's opinion. In Charlotte, of course, Charlotte's a bustling city with banks and things like that. But I'm old enough to remember the attitude of Charlotte. Now, what has happened is North Carolina has kind of grown to the Charlotte attitude. So Woke County here is a little bit the same, but it does bring some nice things with it. The law firm I worked at had an office in Charlotte, and they got new fancy offices while we were in the older offices in Winston-Salem. And I remember one of them calling back in and saying that he couldn't talk long because he had the crew coming in to figure out where they were going to put the pool table in his office. Whereas my office was the size that if somebody walked by, they might hand me their coat, thinking that it was the closet where you check your coats in. So this is, to some degree, merely my jealousy of the accoutrements of the Queen City. This gentleman here, Eric Thomas, in the orange. Not surprising that he's wearing that now. A small business entrepreneur. And one of the things that you have an issue with if you're trying to do a startup business, a small business, you're operating on thin margins. You are the business. And you can't afford unnecessary losses. You just can't. Okay. There's no big capital company, venture capital firm behind you. You're it. So I have a lot of sympathy for what he was trying to do here, operate his business. But then the story gets a little more complicated. He has a bad customer who tries to short him out of $10 and steals $10. So he calls the police. And the police come and want to know the circumstances. Well, what happened? What are you guys changing money for? Talk to me. Talk to me, Eric. And Eric says, guess what? I was selling him weed, and he didn't pay me. He took the $10 I was supposed to have. Well, what's your inventory? And he has like a bag, 12 bags of weed on him that he was still trying to sell, and cocaine. So unfortunately, Eric had failed to predict the response of the law enforcement system, which viewed him as a perpetrator here and not only a victim, and he was arrested. So that's unfortunate. He could use maybe a business consultant to help him with that. Then we have, let me flip this one over here, this gentleman here. Again, a little bit of sympathy, I think, as we move into Christmas time for this last crime. It's Patrick Vandermaiden Miller is in Florida. Gets a wrench thrown into his plans, but not into the scooter he was trying to put together. So he goes into a Target in Florida and steals this electric scooter, and he's trying to put it together outside of the store. Now, if you've got Christmas coming up, or if you've ever had kids, or if you've ever even been a kid yourself, you know what a struggle it is to put anything together to make it look something like what it looks like on the box. And they give you a tiny wrench of the world's softest metal to try and tighten these bolts to 500 foot-pounds of torque. Well, here's poor Patrick out there trying to assemble this electric scooter because it doesn't come ready to ride. And Target has no mercy. They call the police, and the police arrive. And I'll quote you from the sheriff. "This dumb criminal of the week must have thought this was in another state or city where it's okay to walk into a store," he's dunking on California here, "and steal what you want and not face any consequences," says Sheriff Rick Staley on Facebook, also dunking on everyone by bothering to post on Facebook. He didn't get to ride his Razor, but he did get a free ride to the Green Roof Inn in the back seat of a patrol car. Not surprisingly, Patrick was also charged with possessing drug paraphernalia. So again, in the Christmas season, I feel a little bad for him having to try to assemble this thing on the spur of the moment like that. We all know that it can be a frustrating thing to do. So lack of critical thinking skills could have caused him to call the cops. Talk about Eric there. It could be. It certainly could be there. I don't talk about Eric, but I think he'll learn a lesson from that probably, that the cost of doing business in the drug business is sometimes you have to write off a receivable, right? Yeah, he thought it was an IKEA scooter, and it's not the right brand. It's the Razor, and now he's behind razor wire and incarcerated. So let's see. Mrs. Southern-in-law, do you have anything that I have missed? Hello?
No.
She says no. Maybe you heard that. I turned the mic on. She refuses to talk. She's invoking a Fifth Amendment privilege to not incriminate herself. But I appreciate her putting this scandal here, and I didn't knock it over setting a fire, and also the Christmas tree to increase the festivity of this stream. And I will, I've got in my notes, I'll come back on this guy who was refreshed out of the presence of the jury, but I don't think that's anything crazy, but it'd still be interesting to check it out. So that is going to be about it, I think. And, well, it's time to get Saturday night going around here, and I hope everybody has a great weekend, and thanks for tuning in, and we'll catch you guys later. Thanks, bye.